Out of the Hendricks County Jail, here's what you need to do in the first 72 hours to make sure that you're best prepared to fight your case. So you've been charged with a crime in Hendricks County and you went to jail. Now, typically, depending on the crime, you're going to be given a bond immediately, meaning you can bond out before you actually go in front of a judge. Now, depending on the crime, higher level felonies or sometimes domestic related crimes, you're going to be sitting in jail until what's called your initial hearing. And that's the first court date where you're actually in front of a judge, where the judge can tell you what you've been charged with and the allegations the state has levied against you. Typically, at that initial hearing, if you're held without bond, that's the first time where a judge may entertain giving you a bond so that way you can get out of jail while your case is pending. Regardless if you are in and out of jail and you post bond quick, or if you're sitting in jail waiting for an initial hearing, the number one thing that's going to be the most important step is to call an attorney. You're going to want an attorney there for you at every step, even if you're not in jail. The attorney is going to be able to file motions and get you prepared to fight this case in court. There are a lot of things that need to be done at the beginning in order to preserve your rights for later on during the process of the case. And it all depends on what you've originally been charged with. If you're charged with a DUI, getting an attorney on board quick is very crucial in order to make your life as easy as possible while the case is progressing. In a DUI case, the state almost immediately is going to ask for a driver's license suspension. But if you have an attorney, there's ways that we can keep you driving while the case is proceeding, even when the state is requesting a driver's license suspension. If you're charged with something else like a battery charge, having an attorney on board quick can help you gather evidence that you're going to need to fight this case, whether that be pictures, videos, statements from witnesses, things of that nature. An attorney is also going to be able to explain what you can and cannot do while you're out on bond while a case is progressing. In some instances, there might be a stay-away order where a judge is going to say you're not allowed to be within a certain amount of feet of a particular address. There are also going to be situations where a court's going to issue a no contact order, and your attorney can explain to you what you can and can't do for that no contact order. If you immediately bond out of jail before going in front of a judge, when you leave jail, the jail is going to give you what's called an initial hearing date. Now, depending on the severity of what you're charged with, that initial hearing date may or may not happen. Typically, if you're charged with a misdemeanor and you have an attorney can waive that initial hearing date. At an initial hearing, all that's going to happen is the judge would go over what you've been charged with and the potential penalties. But if you have an attorney, they can save you the trip and having to go in front of the judge for something that typically takes 30 to 60 seconds. Now, if you're charged with a felony that's not able to be waived, your initial hearing is a time where you'll have to go in front of the court, even if you're out of custody. But it's always important to never go into court alone and to always have an attorney by your side, even if it's just for your initial hearing. Because at that initial hearing, the judge is going to set some important dates and deadlines, and those dates and deadlines are for your attorney to file specific motions, defenses on your behalf. After your initial hearing, the court is typically going to set what's called a pretrial conference. However, in Hendricks County, they call them bench trials. Now, it's not a real bench trial. These are typically set pretty quick after your initial hearing. A lot of the times, the discovery process hasn't made its way through yet. So even if you went at your first pretrial conference or bench trial date and said, "Judge, I'm here, I'm ready for a trial," the judge will laugh at you and say, "This isn't a real bench trial. You have to request what's called a contested bench trial in Hendricks County." Now, that's a little bit different than many other counties, which will call pretrial conferences exactly what they are, pretrial conferences. But in Hendricks County, pretrial conferences are labeled bench trials. Regardless of what you're there for, an initial hearing, a pretrial conference, anytime you go in front of a judge, you're going to want to maintain a good appearance. And that doesn't mean you need to show up in a full-blown suit, but you also don't want to be there in open-toed shoes, shorts, or a tank top. I always tell my clients, as long as you're wearing a pair of slacks, a button-up shirt, or a polo, that you're going to be fine. You don't need to wear a full suit, but you do want to look presentable for the judge, because ultimately this judge might be deciding what sentence you're going to receive on this case. After your initial hearing, whether or not you go in person or it's waived by your attorney, the state will start sending you or your attorney the discovery on the case. Discovery on the case is all the evidence that the state has. Typically, we'll see that between 30 to 45 days after your initial hearing or after that initial hearing date has been waived. So a lot of times in the first month after hiring an attorney, after you've been charged with a crime, you're not going to get much update because your attorney doesn't have that much on his own end other than maybe a police report. So as far as updates, the beginning of the case, you're not going to have as many updates until the attorney can get through the discovery, review all the evidence, and be able to see what the state has against you. If you're facing charges in Hendricks County, please give us the Marc Lopez Law Firm a phone call. We know we can help you. We are in Hendricks County almost every day of the week. So please give us a phone call, 317-632-3642. And always remember, plead the fifth.